right, hello, and welcome to Season 2, Episode 1 of the Immigration Podcast with our new co-host that you met last time. We'll go around and let everybody introduce themselves. My name is Rob Ratliff. I'm an immigration attorney in Cleveland, Ohio. The Guardians are getting ready to play, and the former immigration judge. And we'll just go right around. Who would like to be next?
I'm Susan Hiller. I'm a former Assistant Chief Counsel with the Department of Homeland Security, and I'm with Hiller Law Group now.
Excellent.
So I think I should go next since
Ladies first.
are you guys also getting an echo on when I'm speaking?
That sounds good on this end. So.
Okay, great.
I did hear an echo, but I don't know why.
Well, I'm Miriam Udine, and I am the newest co-host of the Fabulous Immigration Podcast. I'm a lot of former things: former prosecutor, former public defender, former DHS trial attorney, former immigration judge. And I think Rob introduced me the last time as a person that's saving the world. So currently, world saver.
So not former world saver, because that would be bad for the rest of us.
And
All
hi,
right, sir.
I'm Gary Martin. So I'm a DHS attorney, trial attorney, like a better term, I guess. So nothing as exciting as the rest of you, but happy to be part of your group.
Yeah, but you're not a former, so
Why?
I have
you're
lots
a
of
current,
so,
which is good. All right, so lots of things going on this week. We had a couple of big court decisions. I was really impressed with the Fourth Circuit one, and I don't know, Susan, did you check that out? Did you have a chance to read that?
To be honest, Rob, it has been a very busy week, so I have not had time to read it. But again, if it's consistent with my understanding of seeking admission, being at the port of entry.
Oh, this one was the one we talked about earlier in the week. This was a petition for review at the Fourth Circuit, and it was Diahn, Diahn v. Blanche, and I don't know. It got to the Fourth Circuit, but the individual was pro se at the IH, and the Fourth Circuit remanded, saying essentially that the immigration judge has a duty to develop the record in pro se immigration cases for asylum and whatnot. So I must have picked up representation after the fact, but it was a lengthy decision, but it really delved into the responsibilities of immigration judges in those pro se cases.
Do you recall when the case was?
It was 24.
24. Do you know what location it was at? Did it say it was Atlanta or Charlotte or Virginia?
I don't know.
I'm just curious who the immigration judge was.
Oh, you know what? That was another strange thing about that decision. Let me see if I can find it real quick. Is, a lot of times they don't name the immigration judge. This time they did.
Yes.
Because I remember reading the name and I'm like, oh, okay.
Sorry, former immigration judge is.
Well, and my thought on it was, when I was a judge and I worked at a detained docket, and most of the IHs were unrepresented, and I just felt that was necessary. I mean, because the literacy skills of respondents varies greatly. Language skills obviously very different, but I mean, you have to elicit those questions, because people don't understand what a particular social group is, or what well-founded fear of future persecution, and they just don't understand that. So I mean, I agree with the court that there's got to be some sort of duty there. It's not DHS's duty.
I think, Rob,
Yeah, I agree with that 100%.
I think there's
I'm also trying to look through it. Sorry, Gary.
no, it's okay. I think
Well,
there's
let
a
me-
regulation, Rob. I think that Zoom might know it actually, but I think the department has a
I have a regulation
responsibility.
regarding the government's duty to take fingerprints of
That's being heavily contested right now.
respondents. That it's actually their burden to do the background checks. It's their burden to make sure that the respondent if they're in detention, is able to get background checks. But the one you're asking for, I don't know off the top of my hand on the judges. I don't know if Miriam knows.
No, I'm
Gulf
looking
of-
through it. I can't find it, but I
Yeah,
also want to give.
Gulfavar was the IJ's name.
I also want to give a shout out to the Fourth Circuit for another case where I think this just says it was 2 days ago. Fourth Circuit seems skeptical of policy lifting limits on ICE arrests at churches.
Wait, seems what? Skeptical?
Skeptical.
Yeah, so is it let me see, guys. Yeah, May 6th. Judges on the U.S. Court of Appeals for the Fourth Circuit seemed skeptical Wednesday of allowing a new Trump administration policy that enables immigration officials to make arrests at places of worship. Are you guys hearing anything about that?
No, I had not seen that.
No, I hadn't seen that one. That's great to know. I mean, you would think, since there's certain places where you have confidentiality, right? And one of them is with your priest or imam or rabbi, that if it's out of place of confidentiality, like medical establishment too, that should be a place that's off limits.
That was a big issue when, it hasn't really played out, I don't think, too much, but that was a really big issue last year because the firm I'm with, we represent a lot of clinics and hospitals and medical facilities, and they were all, very distressed about, what was going to happen and what records were going to be disclosed, whether or not they could refuse entry to ICE agents in various parts of the facilities. And, we had to do a lot of seminars and education with that last year because the hospitals and clinics and things were just very, very afraid of what was going to happen. But I haven't seen here in Ohio or Florida, I haven't seen it. I haven't seen too many hospital issues, but they were arresting them at the courthouse, that's for sure.
There's been.
So, Rob,
Go ahead.
sorry, Sue.
No, I'm good.
Rob, when I want to get to the first thing that you and I touched base on this week, which was people getting picked up at their biometrics appointments.
Yeah.
Stu, I think you had on our text message thread talked a little bit about what you were saying. Are you seeing that is what's happening?
Not in Charlotte. I don't know about Charleston, and I don't know if you guys are hearing an echo now. But if you are, let me know. So in Charlotte, there's been no issues with that, even with people with final removal orders. I haven't heard about that in Greer, which is South Carolina, and Greenville. I haven't heard that. Charleston would be the one I'd be concerned about, but I haven't seen anyone on the AILA email saying that.
We've had a lot of clients that were picked up with final removal orders just on their regular check-ins. Their annual report to ICE check-ins. And some of these, a lot of Vietnam refugees, from the 70s and 80s, 90s, getting picked up in those situations and being held. So seen a lot of those. But I hadn't seen anybody getting picked up at biometrics yet. But I think that's coming, if not.
Yeah, it was in an AILA practice alert this week. Let me see if I can find it.
Now, check-ins, I have had people picked up at the check-ins. I don't think there's really an exception to that if you came in illegally right now. But Gary might, if he's allowed to talk about what the policy is right now.
I don't really know the policy.
That would be
That's what
wonderful.
I do. I was just telling Rob I forgot. I didn't forget to do my homework, but I bored all day.
Gary, you're good.
For the whole week. For the whole week.
So if I were to call you as a duty attorney and I asked you if my client goes to check in, they've been here 23 years, but they entered illegally, you wouldn't know. I'm not saying you should know. I'm just saying, is there a policy that they would have you tell us, or would they tell you not even to tell us?
I have
Oh, wait,
not
that's-
seen any policy or heard of any policy telling us not to. If you have a G28 on file, we talk to representatives all the time. So,
Okay.
you know, I read
It's
some
definitely-
I read some of the stories that you guys read. So if I get general questions like, you know, can somebody be picked up, you know, in an interview or something like that, then my thought would be like, I think they can be, because I've read where some people are, but I don't know that. And so, you know, you're familiar with my system, so I don't know where I look to see if that was like a plan. I don't know if they make a note somewhere.
Yeah, it's probably ERO that would have that. And since I think you said you're in a detained facility, or you do more detained cases, you're not hearing probably what's going on with the non-detained people
Right.
as much.
I haven't heard
Yeah.
of anything like I haven't. You know, I've been here in Indianapolis for a little over a year and a half, and like I haven't had any AILA attorneys call and say, you know, the client got picked up, or where are they, or you know, they can't find him, or something like that, or somebody, you know, got picked up at an appointment, and I haven't gotten any calls or emails about people concerned about that. So it could be regional. You know, there are, I imagine, places, different sections of the country that are, you know, more active than others.
Definitely seems like there's not a consistent nationwide policy. It's almost like whatever region may have some bed space this week, they're storming into that area. It just seems very haphazard and random almost.
So the AILA alert, I found it, guys. The echo is just
I know, I get it too.
troubling. AILA members are reporting an increase in client detentions at biometrics appointments across the U.S. Reports have come from a variety of benefit types, including adjustment of status, I-130 beneficiary petitions, work authorization. And it says, it appears that ICE may be targeting individuals with prior removal orders or prior interaction with law enforcement. So that was troubling, as well as that USCIS is expected to pause adjudication of all fingerprint-based benefit requests. Had you guys seen that one?
Seen that, but I did have people go in this week and last week and get their fingerprints. So far, so good on getting them.
Yeah, that became effective, it said April 27th. It's a new security vetting process at USCIS.
So I
An internal memo distributed within USCIS directed officers to submit pending applications for enhanced FBI background checks and withhold adjudication until security clearances were completed.
that did happen. So in the AILA Carolinas, they did report in Raleigh, North Carolina, going to USCIS interviews, and either the officer said, I can't grant it right now, or it's going to be, but both cases were reported back from the private attorneys that they could not make a decision at that time because of the pause for enhanced background checks. Which I don't know what would be an enhanced background check. I mean, I'm speaking as a former ACC assistant chief counsel, like, you know, Gary and Mary. They do it. They already do an FBI name check. They're already running it through the FBI systems. They're running it through TEX, which is the Treasury Enforcement. I don't know what the C stands for, but it's that's another big database they went through. The only thing I could think of is that now they're running it through Palantir, but they've already they could run it through Palantir anytime, which Palantir probably has comprised everything they took from Doge, the Social Security, tax information, Facebook, social media. But I would think
Hey,
that
Sue,
it's rapid. Yes.
are you aware of any lawsuits against Palantir? Do you know of any organizations that are trying to figure out how Palantir is surveilling people for immigration purposes?
I'm not aware of any, but there should be. It should be a class action. I'm actually surprised that AILA or the other immigration, the immigration council, haven't heard of one though. But yeah, because I will tell you, last year I went to speak to the South Carolina representatives at the National Day of the National, and one of the things we were trying to advocate for, because we knew. Do you guys hear the?
Yeah, you've got some sort of echo going on. I'm not sure what.
I don't know if we could pause and because it's hard for me to.
Yeah.
My ADHD is while listening to myself.
Change your speaker output or something maybe.
I have no speaker. I put no headphones. Well, it's not doing it now.
Yeah. Still, maybe when you're sitting closer, it seems like
No, I think Gary just put his headphones off or in.
Yeah, they're not plugged in.
Oh,
No.
it's not.
I was fumbling with them, but I'm.
I don't know what did it. Okay.
It's when you came forward.
Really? Okay.
Yeah. Yeah.
Okay. Well, I'll sit for it.
Yeah. I did see there was a suit filed just a couple days ago in D.C. on the biometrics for the detained inmates.
Oh, yes. I like that
Detained
one.
respondents. Yeah.
I think Ayla did that one.
Yeah. If generally they file it in D.C. Because that was an issue. I mean, we've had some T visa applicants that have been detained and
Yeah.
they won't do it.
TU and DAWA are all the victims.
Yeah, you can't. The immigration courts won't order it. They don't really have the authority to, anyways. And DHS attorneys really don't have any authority to make it happen either.
Well,
I mean, they can put a word in, but
not under this administration, probably. But
yeah,
I mean, I would write, for example, with the non-detained cases, if they were having trouble back in the day. This is when they could walk in. So it must be like 6 years ago, maybe more than that now. Time is flying. But I would actually write a note on the little fingerprint thing that you guys would have in the courtrooms, the judges. I'd actually write a note to please allow them to go in and to get their fingerprints done. And I put my name and my title and I'd sign it. And they were able to get it because it's holding up the proceedings and maybe holding up the decision. And I wanted to make things easier for the court and for the government. It's more efficient. So I think there's things we can do. It's just whether or not the administration or your supervisors allow you to do that.
Well, one thing that I found interesting in my brief time was in federal court, the agencies, FBI, ATF, whatever, those agents respond to what the U.S. attorneys tell them. Like, we want this. The relationship between the OPLA attorneys and ICRO is not quite so hierarchical. You guys don't really get to order them around quite so much.
It depends. It depends on who's doing it. I mean, I think Gary can speak to that. If it's a supervisor that is, I don't know, I could say it's not just get along, but definitely if they're friends with those other supervisors in ERO, or they're scared of that OPLA supervisor for whatever reason. Like, I guess you could call it respect, but it might be respect out of fear that they might get in trouble if they don't do it, because technically OPLA is the advisor. And if they're saying you need to do this, we can't tell them, we can't make them do it, but we can advise them. There's legal liability if you don't do this. And when it's coming from a supervisor, a certain supervisor to another supervisor, it can get done.
Yeah, so we're all attorneys, and we have all had the experience of right? Our clients don't always listen to us, don't always take our advice. So client control is something they don't need in law school, um, and it's not something that comes easily to me, um, which is not. I'm not disparaging the client at all, but I'm just echoing Sue's uh, sentiment that we have a good working relationship with the ERO officer, um, which I have. I do whatever I can do for people whatever they can. We all have the same goal in cases. But you guys are experienced probably ACC's work. I don't know, ACC's in fees, but and a lot of officers. A lot in the last year. So just take some time to establish relationships both with the daily attorneys and then also EROs. Things can get done, and it's not like a violation rule or policy.
No, it's just kind of the working relationships. It was different for me. I expected it to be a little bit more of a hierarchy.
No, you're absolutely right, Rob, on that. And the problem too is that, like when I started way back when, we were all co-located in the same building. And they had to come to us back in 1997 to get signatures for certain notices to appear, depending, I guess, on the location. But in Boston, for example, for legal sufficiency, especially for detained cases, they'd have to come to us and get a signature for legal sufficiency before they were allowed to issue the notice to appear. So it was more like an AUSA having to say, yes, we'll prosecute, because we could say, no, we're not signing off on it. You need to go get the certified conviction record. We need to see that first. We have to see the complaint. They may not have sufficient documents or not meet the qualifications. So we got to know them better that way. And we were co-located with them. So that made a big difference as well. And then now everyone is spread out and ERO just does what it wants to do. And some of the time we were actually, sorry, I'm close, but it's still echoing. Some of the time they would actually, we'd have to talk to them after they issued the notice to appear on the issues with it, and by email. So they don't get to know each other.
But that's part of the whole WebEx thing. I mean, it's so great and it's convenient, but you're not seeing people in the hallway. You're not talking to the attorneys on the other side. You're not building any kind of confidence with them or even with the judges. So it makes it much more difficult to just kind of operate in a friendly sort of manner. Much like the internet's made everything much more adversarial. The internet-based hearings create situations where well, I'll never have to see him again, and you click the button off, and so it makes it harder.
You're referring to social media and how brutal it is.
Yeah. It's infecting everything. So.
Keyboard warriors.
Yeah. Well,
I really,
yeah. Oh, go ahead.
I want to chime in on that because, having been a public servant for as long as I had been and pivoting into civil liberties and, representing people on the immigration side was a real eye-opener for me. I did not understand or appreciate how much privilege we had as government servants. Trying to get a hold of someone at OCLA, an ICE attorney, when I don't have their email, that's not even being published. I don't know who to expect in court on a big case. I can't figure out what their personalities are like. That's a real deprivation of, as you said, the relationship building that's essential to being able to broker good outcomes for our clients. And on a particular case, I remember that it was very significant to me and a number of people in our community. So we went in and we knew that we were going to take a removal order. We were hoping we could get voluntary departure. Needless to say, the client had health issues, so we asked the judge if he could facilitate by writing on the order that this client would be removed within a certain time period. We asked for 2 weeks. And DHS didn't have any objections to that, but the judge told us that he couldn't do that. He didn't have the authority to require ICE to remove our client by a certain date. But we worked on an informal agreement with the DHS attorneys, and they agreed on the soft time frame. What they did with ERO, though, is just send out an email saying, like, hey, this is what we agreed to in court, and now you guys work it out, basically. And ERO is even more difficult to find, to figure out. I remember going in person to the Dallas downtown location, and I was kind of appalled because as an attorney, I thought that I would be able to come into the building and speak to somebody, but the security guard just kept me and the other person that I was with that day at bay, kept us outside and said, was kind of suspicious about why we were there in the first place. So we were trying to explain we're here for our client, try to talk to somebody who's going to facilitate the removal, what flight he's going to be on, what we can expect that we need to tell the family. It was very difficult. It was so what's the word I'm looking for? Obscure, how to figure our way out through this, not knowing the people that we could count on, that we could reach out to. I'm not saying that they were discourteous. It's just that there was a dearth of information and communications, and every day I would be, frantically checking email for some good news. He was ultimately put on a plane 2 months after that date in court. So the 2 weeks was certainly not something that was implemented, and that was unfortunate because they had agreed to it, and then ERO appeared to be working around that, but then they kept telling us that logistically they couldn't. They had orders from on high. Headquarters had their eyes on this case particularly, and the country that he was being removed to only had certain flights. So it was really complicated. And I never really appreciated how difficult it was on this side, having been at DHS and having been at DOJ. I don't know how many of the people who are currently there, aside from Gary, can appreciate how many hurdles we have to overcome to get basic information.
I missed a little bit because we're not supposed to have solicitors, but there was a solicitor.
It wasn't anything brilliant. I'm just saying it's so eye-opening how difficult it is on this side. And, having someone like Gary that you can reach out to and get information from, for me, has been the exception.
Well, and it's even now we have the detainee locator, and we have the the EIR case status and the ability to check receipt numbers on USCIS. I mean, that's all fairly recent. I mean, in the early 90s, mid 90s, almost none of that existed. But you could go to the courthouse and you'd see people, which was the other side of it.
But I'm with Miriam, okay, and for several different reasons. But I could go on this topic for a long time. But just to go with contact information, I took it completely for granted that I could pick up my phone, that I had email lists and people to get in contact with. Then also the fact that this is a whole different ballgame now. After COVID, everything shut down, windows closed, and ERO became more private as well. So didn't USCIS, and they never really reopened their doors for InfoPass checks, so where you can get anything resolved. That I used to hear when I was a government attorney, that private attorneys would do an InfoPass appointment, were able to go in and figure out what was going on with their case. So you could have a case where you don't have a receipt notice, and that way you can't put it into that system. If you don't have a receipt notice, you can't talk to anyone on the phone on that USCIS hotline. It takes forever to get through. And there's no way around it if you don't have a receipt number. It's like not having your credit card number or social security
Yeah.
number. And with ERO, they do act now very, the way you said it was probably best, Miriam, but they don't know why. They act like you're suspicious to be there, just to show up alone as if they are a secret CIA type building. And why are you coming here? But it's the only way to sometimes go there and talk to a human being, because otherwise, the email that we have in Charlotte, it's for Ayla, but they never answer it. And they don't answer their phones. And I know they don't answer their phones because the ERO officers over there told me when I work for the government, they don't answer that phone. So,
And even on that case that I was telling you guys about, we had requested humanitarian parole. It was, of course, during a time when the congressional offices of ICE were shuttered. So, in essence, everybody could hide behind the shutdown, and no one was responsive to this request. We're submitting basically an application for a person's release, a person that doesn't have a criminal record, to say he's got a really serious health condition. And they just sat on it. Essentially, they're allowed to ignore requests like that. And I think that is an erosion of the best of the American promise. I mean, by definition, a humanitarian medical request is urgent, and should not be at the mercy of the government's inability to get its shit together. And just because it's shut down, we don't have to answer this attorney. Once the government was back up and running, I still did not get a response to that request. So I think, again, not Gary, and it's not an indictment of the agencies themselves. I think that there are just offices that don't feel they have to be responsible to requests like that. And somebody is allowing them to be shielded that way, right? Because there isn't a fear of, if a private attorney complains about what I've done, I'm going to maybe get in trouble, and therefore I should probably do my job and be responsive. That's how it used to be. I'm not saying that with great success, but and now when we understand that the climate is based in some of what we were discussing earlier, and I was just reading also, of course, that USCIS and its vetting is now making it much more security centric, and people are being asked a lot about their views on Israel, and what organizations they've been affiliated with, whether or not their social media posts demonstrate any sort of pro-Palestinian alliances. I mean, it's not coincidence that all of these things have converged. And basically, a lot of immigration attorneys are feeling like they're operating under rapid fire continuously in an evolving landscape that is unfavorable to respondents. Although, again, there are minor shout outs here and there. Went to the 11th Circuit on that case that we had shared amongst ourselves, where bond hearings are now, I think, available again to some class of respondents. So that's good.
Yeah, that's an interesting split. It's going to have to go to the Supreme Court, because the split between the circuits is very narrow, but it's very specific. I mean, it's either yes or no.
I don't know if I want it going there.
It's interesting. I mean, I read through all the opinions this week off and on, and it really comes down to just how they parse the one portion of that phrase of seeking admission and what it means. But
What dumbfounds me, Rome, on that is like they're coming at it as if the term was invented today. it was back during Ira, and it was back during that determination, and it was completely under expedited removal. It was about somebody seeking admission at a port of entry. Like, once you've already asked to come in, and they say you're entering without inspection, they find you at the border, and they parole you in, or you've already come in, but you didn't ask to come in. You weren't knocking at the door saying, "Can I come in?" You snuck in. That's not seeking admission, and that's the way Congress saw it, was that you'd have to be caught at or near the port of entry within a certain amount of time frame. Because obviously you can go to the interior for 23 years and then you could go hang out near the border. That doesn't mean you're seeking admission because you're near the border.
If someone enters though illegally at somewhere along the border, why are they treated as someone who did the right thing and went to the point of entry and asked for it?
I get that, Gary, but the law was created the way it was by Congress, and it was meant to expedite removal at the port of entry. And I understand this administration wants to see it differently because they know they can't get Congress to enact the law the way they want it. They should go through Congress if they want a new law. But this one,
Yeah, it's not just this administration, though. I know we already spoke about it last time, and how you taught at Bletchley. And I have a great deal of respect for that experience that you had, and all the officers that you influenced. But I was hired, and we had the same interpretation. I was hired police when I was working at a border. So if you were caught in the interior of the United States and you had not been admitted, then at that point you're sent to the United States. I don't know that that's right or wrong. I haven't read all those decisions in the Senate right now, and we have heard oral arguments. We haven't issued a decision.
Well,
Also,
yeah, but to your point, Gary, that was one of the things that always bothered me about that rule and the way it was interpreted previously. Is it put someone who knocked on the front door and said, "Can I come in?" It put them in a worse position than someone that sneaks in and hides out for a while. And I found that to be somewhat distasteful. But it incentivized the sneaking in process, and I think, to me, the biggest problem with the courts that are finding that people that entered without inspection are bond eligible is that it disincentivizes people that came in without inspection from trying to get legal. Because if that interpretation is correct, then the courts that have said that they're eligible for bond is basically said because they're present in the United States and they are not seeking admission. They are specifically, laying low. And that means that they are eligible to apply for bond. So if someone came in the country without inspection and they've been here for 20 years and they've got a sick child or they've got a spouse and they want to do something to get legal, they're disincentivized from trying to do that now because as soon as you raise your hand, you're subject to the mandatory detention.
They've been here laying low for 20 years. They're not working to get legal.
Well, but
20 years
your
to work to get
circumstances
legal.
change.
Yeah, they
Your
do.
circumstances change.
But not all of them. Whatever, many millions are suddenly like.
Yeah.
And if the courts are saying, "Hey, just let them go back out and lay low again and do nothing to legalize their status, continue to work without authorization and drive without a license or insurance."
Well, and that's the concern here, I think. Yeah, and I think that's the concern here because the 11th Circuit, in their finding that these people were bond eligible, I think their strongest argument is the fact that it's been this way for 30 years. Everybody's accepted it this way for 30 years. And if we're going to make this kind of a change, that needs to be congressional, not a bunch of judges sitting around saying, "Hey, we're going to reinterpret this."
That's why I wanted to mention it. Like, I don't know that if they said that it's been this way for 30 years, and maybe it has in the 11th.
It's been 30 years. It's almost exactly. I actually briefed it that way.
Yeah.
I
So
started 11 years ago in the Fifth Circuit, and it was not that where I was practicing. We absolutely charged everyone with ZWE as seeking admission. We did it in the NTA, and we treated them that way. But
I'm
Well,
gonna,
and I think what we're going to see, and I don't know, Susan, you've probably done a lot of bond hearings recently, but I think what we're going to see is even if it is held to be bond eligible, then the courts are going to do a complete 180 on what on presence, family ties.
Oh, they've
history
already
of the
done
United
that.
States. Yeah,
I'll tell you about that one.
yeah, 2 years ago, I would lead with that. He's been here 20 years. He's got a job. He's got a wife. He's got a family, and that's bond eligible. That's going to be, well, that shows that you're trying to hide out. That shows that you're a flight risk, and that's going to be the basis of detention. Where 2 years ago, that was the reason to let somebody out on bond.
Okay, let me I want to go back to this argument because Gary's being an excellent steward of the Department of Homeland Security. You're doing great.
I'm not allowed to talk on behalf of.
Oh, I know you're not, but I love the brain.
Yeah.
I love the brainwashing for you because it keeps you safe and you're where you're at. However, this isn't about a moral compass as far as the law. Like, do we think this person be treated better? This one. What it is about congressional intent at the time the law was created. Right. So I may not like. No matter what law it is, I may not like it, but at the time the law was created, I worked for INS. And I became an attorney right at the time. I was a law clerk before that, but I was with INS, and then I became an attorney with them. And I was there as Congress was defining what seeking admission meant. So we can't change that because not you, Gary, but people are not happy that the people who came in illegally aren't the ones that they should be detained, even though they've been here 23 years and have 3 U.S. citizen kids. If we don't like that, then you go to Congress and you ask Congress to change the law. Although I think if they were to go to Congress, Congress would make exceptions for people who have been here 20 years, U.S. citizen kids. But they could create a law where they start applying it to the people who have entered, in the last this year. But the law is what Congress intended at the time. That's my take, because I not only was taught that at the very beginning when the law came out, and we did it for 30 years.
But you should not fear this going to the Supreme Court then, because you're a strict constructional.
No, I do, because I do find the Supreme Court to be corrupt at this time. I do believe that Thomas is implicated. Well, he is named in the Epstein files, and I will say that because it is true. And whether he did what they say he did, I tend to believe child victims, though. But I do believe that they have blackmail on some of these Supreme Court justices, and I do believe they're corrupt.
Don't you think, though, like in the 11th Circuit points out that there's really two congressional intents to take into consideration? One is the intent at the time, but two is 30 years of acquiescence. If this was not being applied in the right way, then pass a law or fix it.
Mm-hmm.
But I have a low opinion of Congress. I mean, they just shove everything off to.
Like that. Does that ever apply to the king?
What's that?
What?
Latches? Yeah, latches does not apply to the king. Right?
So, yeah.
Mm-hmm.
But it.
Can you say, like, if we've been making a mistake for a couple of years now, we can't do the right thing?
Yeah.
If it's right. And Sue, to your point.
That would be 30 years of malpractice for me, Gary. I would not like that.
No, I'm just saying, I don't think it's a universal truth that across the country it's been applied that way, because that's not been my experience since I've only been here a third of the time, that Sue's been.
I had no idea that in Texas they weren't.
I was in Louisiana, but we were doing that, and we had counsel that would object, and that was our
Didn't know that.
interpretation of the law. Is that if you're caught here and you haven't been admitted, and you're seeking admission, and if you're not seeking admission, then you can go home. Like if you're here but you don't want to be here, kind of thing. Like, then what's the problem?
Is that because they were so close to the border? I mean, because that's the expedited, that's where you can get into the expedited removal. Even though they weren't put into it back then, they were still being considered like they qualified for expedited removal if they were within so much time and within so much distance from the border.
I remember that. Yeah. From
Oh, what was
days
did
of
the
miles or something.
yeah did the CBP's jurisdiction has changed since then? They used to be limited to much closer to the border, aren't they? Don't they have?
There are 100 nautical air miles, which is approximately 110
Yeah.
miles from
But did it?
any port of entry. That's why when they came into Charlotte and when they came into other places, they were able to say the international airport, they could do 110 miles within that. That's what gave them that authority. They had never
Yeah.
used it like that in the interior, but they always had it.
Yeah, and that's I explain that to people here in Cleveland because just Canada's only 20-30 miles to the north. It's a lot of water, but in the wintertime you can walk.
Yeah. That's what lets them do the bus stops, stop buses to within 110 nautical miles of a port of entry. I have one more thing to say on Palantir, by the way, Miriam, because I heard this on a podcast recently. In the United Kingdom, anyone who works for a government agency, if there was a specific government agency named for the United Kingdom, I don't recall what that was, but they said if you say anything negative about Palantir, you can get fired and you will not receive your retirement pay.
For the UK.
And
Wow.
I think it had something to do with,
So,
yeah, and they were voicing concerns, particularly because they were using their technology to commit genocide in Palestine, Gaza, Lebanon, and they didn't want to be. Well, they didn't agree with that, and they also didn't want to be implicated in human rights and war crimes. And they were voicing their concerns and saying we need to not use Palantir. And that's when they were all told, "You won't say another negative thing about Palantir or else." Don't worry, Gary.
Yeah.
It's coming to you soon, too, Gary.
Some of those free speech cases in the UK seem very oppressive. I mean, obviously they don't have a First Amendment, but still.
Yeah, but we do. And Florida just actually arrested a student for putting a post just saying she didn't like Israel. The state of Florida is prosecuting her, and she's detained, and she's a U.S. citizen.
she's not the one that posted about dropping a bomb on something. is she?
What was that? I couldn't hear you, Gary.
She didn't have that little remark in a group chat about asking Netanyahu to drop a bomb on her.
Drop a bomb? But I don't know. But what would that mean? Drop a bomb on me?
Oh, I don't know exactly what her phrase was, but it had something to do with asking. I think he meant it in jest. I got arrested.
But that's not illegal in this country. We could say
I don't know if
drop a bomb on Putin.
Now that
Is that
you
illegal?
dropped the bomb on me song is going to be stuck in my
I know,
brain.
right? Drop a bomb.
All those old people sitting around.
What does that even mean to her generation? We don't know. But what's wrong with saying it's not the U.S. president? She's not saying it about. She's saying it about some. We've always been allowed to do that.
Well, I mean, you can't if you have a group project, like say, bring a school shooter in, put me out of my misery or something like that. So I don't know if that's. I don't know about the case. I was just asking if that's.
Oh, I don't know, but my understanding was she just said something negative about Israel.
It might be more along the line of calling in a bomb threat or something like that got her in trouble more than the subject. But if it's the same person,
Oh,
no.
That's the old scene from the airplane movie, right? Where the lady yells across the, "Hi, Jack."
but Gary, Did she really? I mean, I don't know. I mean, there's a lot of false flags these days.
Yeah, I don't know. So I haven't been following it. I read about a student who was arrested for something she posted in like a group chat
Hmm.
that she thought was a joke. That somebody reported her, but I don't know what state she's in. I don't know if it's the Florida case or not, but it had something to do
Okay.
with like drop a bomb on this meeting or something like that. But I think she said like in the group chat like Netanyahu dropped a bomb on me or something like that. She got arrested.
Yeah, that's the same case, Gary, that Sue is talking about, I think, because it's April 2026
Yes.
and it's in Florida. And it's, you guys are describing the exact tension that's at, the pinnacle of what we're experiencing in this country, because her public defender is arguing that it's her First Amendment right, it's not a credible threat. And of course, the people who are behind her prosecution are saying, the same arguments that they're making against Comey and others. And I think that student protesters and people like Rumeysa Ozturk and Lika Bordia, all of their cases resonate in First Amendment, basically. Unfortunately for the student protesters, I think this administration has been very effective at chilling their speech.
Hmm.
We're not seeing them on campus anymore, even though the genocide is ongoing. And with respect to Rumeysa, she's been released. That's right, Lika has been released. But we've got other First Amendment political prisoners, is what I think of them as, people like Yaqub Ira, even Salazar Sur. There's just a lot. And again, it can't be a coincidence that all of this is happening under this banner.
They're arresting a lot of, I heard, they're arresting a lot of Iranians in the LA area right now, too. Again, and I don't know the circumstances behind it. But again, I feel it's just targeting.
It is. I don't think the war on terror has ever ended. And especially in Texas right now, the politics are really ugly. So I also feel like there's always a minority group that's propped up to be martyred for the cause of, midterm elections. And it's definitely our turn. But we've got Governor Abbott shutting down everything Muslim, prohibiting religious holiday celebrations at parks, shutting down universities that have Islamic components. And of course, he's designated organizations like the Council on American Islamic Relations a terrorist organization, completely out of his constitutional authority to do so. So I'm getting tired, to be honest. I feel really cranky and bitter, especially this week. A dear friend of mine reached out. Her father has a biometrics appointment, and based on his history, and I had shared this with Rob. Rob said, "Oh, that rings all the right hysteria bells for this administration." So if that AILA practice alert is true, we would expect that he actually may get picked up. That's scary.
I
People
have a
who
suggestion
are, yeah, Sue.
on that one. You can, as long as it's before the biometric date, you can go onto USCIS and reschedule it, and you can pick another location.
We did try to reschedule it. I think it's in a good area. I mean, for what that's worth. What are you guys seeing on average the extension time is? I thought it was 1 to 2 weeks, but someone else actually told her 3 to 6 months. I said, I seriously doubt you're going to get a 3 to 6 month extension.
Oh, it's usually
The last couple extensions I did were all 2 to 3 weeks. You
Yeah.
know,
they
right
won't
around
give
there.
me that anymore. They would only, when I went to reschedule, it was basically within 10 days. They wouldn't even let me go 2 weeks out.
Yeah, it's pretty quick.
Mhm.
Been pretty quick. And Miriam, that's an interesting thing because I've seen some of those articles about the Texas designation, and I think Florida had done something similar with some of those.
Exactly. Yeah,
Has there-
both attorney generals.
Yeah, what has been the local fallout? They have they I agree that the governors don't really have the authority to do anything, but I mean, have they implemented any kind of like criminal law or
No, and I
pursued
mean,
anything on that? Is it more
the
just
the the thing
for
about that
show?
terrorist designation anyway is that the only thing it really prohibits the organizations from being able to do is acquire property. So I don't think that
Mm,
there's a what's the word I'm looking for? A concrete kind of deprivation that the governors or attorney generals are achieving through these kinds of acts. But that's not the point. The
yeah.
the it's about the environment that they're creating,
Yeah.
the absolute emotion that we all feel. Understand when I say we, I'm talking about the Muslim community I'm a part of here in Dallas. um, that we are being deliberately excluded from civic life. And
Mhm.
when we see people in our communities being picked up day in and day out, people who have been here for 30, 35 years and have led really, like have been model citizens, have led productive lives, excuse me.
Allergies. But can um, I just want to say something because I feel like for the last 30 years, maybe less than 30, a little less than that, because 2001, I was brainwashed into thinking that Muslims were scary. And I want to apologize if used to thinking that way back in 2001, but I was, after September 11th, we were told that it was done by these individuals, mostly from Saudi Arabia, that they were of the Muslim faith or Islamic, and that they hated us. And it's not true. I mean, we're learning now. I'm just going to be controversial, but there were Israeli agents in the building in the Twin Towers that were Mossad agents. That the FBI van with I think some of the also the Israeli other agents or Mossad agents across in New Jersey, and they were cheering on as the World Trade Center went down. They were questioned immediately. We know that I know that this was not an Islamic attack against America, and anytime I come in contact with somebody of the Muslim faith, I'm making sure that they know that I care about them, I love them, and I don't. And I apologize for ever believing what I was told, back when I was with Legacy INS, because I know that the entire government was targeting people from Islamic countries and it was wrong. And I just wanted to say that.
So I appreciate that. Not sure what the comfort level in our room is right now, but Sue, you sound crazy enough that that's convenient because it allows it allows your views to be dismissed. Unfortunately, I mean, I don't think there are many people
I'm not crazy.
who agree with or even appreciate what you're saying. So I'm I'm glad you had the courage to say it, but we've got a long way to go.
We do, but I think there's more people in the government that have been there a long time and military that I speak with that are friends of mine that feel that they were unfortunately used by the military industrial complex to engage in wars that they weren't there for the reasons they thought they were there.
I feel like Rob and Gary are tuning us out slowly because we've diverged from immigration straight into crazy controversial politics. So you and
Oh,
I can do that after the podcast. Sue, I would love to have
absolutely,
that conversation
absolutely.
with
But what
you.
I'd like to, I just still think the Muslim community and the immigration community should be treated fairly. I think we all agree on that, right? Fair due process.
Oh yeah, yeah, and all the groups have fallen into the crosshairs of the machine at various times, and will continue to happen. And I know one of Sue's favorite sayings is, we're coming for you next, and
That's true.
yeah. So there's always these patterns, and there's always these things, and there's always historically there's always a scapegoat. That's how one group rises above scapegoating somebody else. So
We're all in this together.
Gary, you gotta wave your arms, keep those lights on.
Keep the electric on. Yeah, the shutdown's over. I don't know. Hope they paid the bill.
Oh yeah, you're getting paid now. Congratulations.
Yeah.
Officially paid. I'm happy for you, Gary.
Someone's listening, apparently. So.
Yeah.
What you're doing
Well,
is
you know who's not?
he's doing
You
a
know
good
who's
job.
not getting paid, and I just seen this earlier today. Was they shut down the DHS detention ombudsman's office?
Well,
Did you see that?
wouldn't that be something that helps us? Like when
Yeah,
our
yeah,
client has a
seriously.
medical issue?
Yes. Yeah. It only been in place for like 4 or 5 years, but they shut it down already.
Yeah, because it helps us.
Yeah.
I mean, didn't they get rid of the USCIS ombudsman? I think.
Oh, I don't know about the USCIS one. I know they did. Just the detention ombudsman came out today or yesterday.
I
or
think as soon
a
as
day
he
or two
came
ago.
in, he got rid of that one.
Yeah.
Oh, and Miriam, one thing on that detention thing, because you could have sued, and right away that would have probably gotten more notice at the federal district court, because you're absolutely correct. When they're in detention, and you have to realize it's the GEO group or at the other group, but you know, it's not just the detention officer that she's writing to. He may be out on leave, and if that detention officer's out on leave, no one's getting that message. It's the people at that prison that they don't, in my opinion, some of them don't care. It's just their job. They show up. They're not part of the agency, and so
Or they're in a county jail where it's even. I've got a client right now that's been in the county jail for 8 months. That's no outside time. It hasn't been outdoors in 8 months. And
wow,
yeah,
I think
That's crazy.
yeah. So,
Yeah, and we had a client who, when I would request the nurse, I had the email address of the nurse at the detention center. He had lost a lot of weight, obviously. So I emailed her and I'm like, look, is there any way that he can get an Ensure? Because they have those drinks for certain people. And they, after my email, instead of giving him the Ensure, she didn't respond. But my client told me that every night for 10 days in a row, they would come into the cell at 1 o'clock in the morning, turn on the lights, draw him into the nurse's station, weigh him, and take his blood. Can you imagine? Like it certainly felt very punitive because I was asking for him to get the care, the additional, TLC in the bottle of Ensure, and the way that was processed, it almost made. I did actually tell my client, I will not ask for anything for you anymore if that's right. That was what the intended consequence was. The intended effect was.
yeah. How dare you?
And of course I would ask for him, but I mean, it was painful because he asked me not to ask for anything anymore. When I would, message him, are you eating well? How's your weight? Do you feel like they're giving you the nutrition that you need? He's like, please stop asking them to do anything for me.
I've been surprised because I monitor it, and it's the type of things we used to do, 20 years ago, but there has not been many 1983 actions or Eighth Amendment claims filed, and I think some of it is that. I mean, people fear the retribution because most of the people that are detained are not hardened criminals. They're not people that know how to thrive and survive in that environment. Most of these, the gentleman that's been detained for 8 months is a businessman. He owned a business, and never had a speeding ticket essentially. So, yeah, they're fearful to even let us know what kind of things they're suffering, and I think I think a lot of those Eighth Amendment, 1983 kind of claims need to come forward to, kind of resolve some of these situations, but difficult. I mean, how,
First Amendment as well. I mean, they need spiritual help while they're in there because, like you said, they're not this. I have a mother in there of a 2-year-old. I even sent in. That's the one, Rob, you're helping me on. I even sent in a report from a psychiatrist on the hardship to that 2-year-old U.S. citizen child, and it's been since January she's in there, and now the 11th Circuit has ruled she has a right to a court hearing, and I'm still waiting on Alabama to grant that habeas. But I told her you should ask for a Hindu priest, and if they don't provide you with that, keep asking and let me know, because then I can also put in there the First Amendment violation of why she should be released as well.
yeah. And I've only heard it anecdotally, but I think some of the fear too is the threat that they're going to send you to some place you have no familiarity with. We're not going to deport you back to your home country, but you can't stay here. We're going to send you to, wherever, and that's pretty fearful for a lot of people too. So your willingness to speak up and tell us what kind of deprivations they're suffering. All right. Any final words?
Well, season 2 is going to be riveting.
It is.
Hopefully it's going to get better, and we'll have more positive news to give.
Yeah, positive news would be fun.
Yeah.
Sorry, I feel like I was a real downer on today's. I'm going to aim to bring us that happy news on the next podcast, guys. But I think it's just a testament to the times that we're going through, right? So glad to be able to share my pain with you on our podcast.
It's the Cathartic Immigration Podcast. We're ready for season 2. All right. Gary, good to see you.
Great to see you, Gary.
Thank you again for inviting me. You
All right.
allowed the devil into your den. I appreciate it.
Tell all the judges we said hi.
Yeah, and it's better the devil we know than the devil you don't know.
I appreciate that. So it's always good to see you guys.
You too,
We're
Gary.
all in different
Yeah, we
states,
love you,
so
Gary.
This
All right.
feels nice.
All right. Thank you guys, and I'll hit the stop button now.